Good evening, gentlemen. Welcome to the round of 16 of the virtual rounds of the Football Law Annual Moot. It's wonderful that we have you in this session. It's been a journey thus far, and yes, an opportunity for you to make the submissions before an arbitrator on whichever side you have been allocated. Before us is the Adekunle Ajasin University as the appellants and Cavendish University as the respondents. You are before the arbitrator Martin case. I will now proceed to open the session that the arbitrator will now officially take charge of.
Perfect. Thank you for handing over the word. All right. Welcome, everybody. I would also like to congratulate you on making it this far. At the outset, let me introduce myself. The name is pronounced in Hungarian as Martin Kiss, but you have seen it spelled also Martin Kiss with the K-I-S-S at the end. I'm a counsel at Sila International Lawyers. I'm from Hungary and currently based in Bulgaria. I have the pleasure of being your arbitrator today. The first things first, I think take a deep breath. We are, after all, in arbitration, and second of all, we are in sports arbitration. And I think in sports, it makes all of us good colleagues, and we know that we are friendly. Inside the courtroom, we compete like we would on the field, but outside of it, we stay friends. So with that being said, the first things first is I have seen your name in the messages, but I would like you to introduce yourselves, starting with the appellant and then with the respondent. So the appellant, please introduce yourselves.
Profound greetings, Mr. Arbitrator. I am Adekunle, and appearing with me is my co-representative, Ulukayo Dipo. We announce our appearance for the appellant, Mr. Arbitrator. Thank you.
Thank you. Now for the respondent.
Thank you, Mr. Arbitrator. Daniel Walusimbi is my name, appearing for the respondent in this matter, with my co-counsel, Kubirizatwah Morgan. Thank you.
Thank you, gentlemen.
From Cavendish. Yes.
Perfect. Thank you. Now that being said, normally this would be asked, and as I've been allocated to you, I would like to ask first whether you have any objection to the composition of the panel. This would be asked frequently. So first, for the appellant, is there any objections?
Nothing from our end, Mr. Arbitrator.
Perfect. And then from the respondent?
We have no queries. It is okay.
Thank you. I appreciate that from both of you. It would have put us in quite a pickle. Nonetheless, moving forward, before we proceed with the merits, with your initial pleadings, are there any procedural matters that you would like to discuss from either side? Appellant, any procedural issues? No? And for the respondent?
Yes, we have a procedural issue on the admissibility of this matter before this honorable court. Yes.
Go ahead, please.
Go ahead. Once again, good evening, Mr. Arbitrator. The respondent disputes the admissibility of the matter before this honorable court due to the failure of the appellant to request the grounds for the appeal decision within the 10 days as required by Article 15.
Let me just stop you there for a moment. Going into the jurisdiction, that's not per se a procedural matter that will be discussed in the jurisdiction section when you do your pleadings. Initially, the procedural question is, for example, if I have to rule on any specific document, I have to rule on, for example, certain witnesses, something that will determine the procedure of this hearing later today. So in that sense, I haven't seen any submissions made to that effect, but are there any that we have to discuss as a preliminary matter? Is there? Yeah or no?
We don't have.
No. Okay, perfect. So I understand. I will give you that moment. You'll be able to plead on that aspect, but that will be within the main pleadings. So now, given that we have Adekunle Ajasin University as the appellant, so I will give them the floor. Now, What we're going to do is I'm going to set a timer. I will give you your 15 minutes. When the 15 minutes ends, should you require additional time, I will allow it up to a maximum of 5 minutes, provided that the other side can have the same. However, the other option that you may have is that if you want, you can finish within the 15 minutes, allow the respondent to have their 15 minutes, and then we can have extended rebuttals. So we will see how you move forward with it, but please, by all means, you may begin your pleadings.
Thank you very much, Mr. Arbitrator. Before you today, this court of arbitration is an employment dispute between Power Stars FC and NED. And although precisely our statement of facts and our brief of argument contains the specific facts analysis, however, for the purpose of this submission, we have distilled 5 issues. And for the purpose of the deliberation, I'll take issue 1 and 2, while my co-representative will take issue 3, 4, and 5, while I take the prayers respectively. I proceed with my argument. The first argument is whether or not DRC, that's the FIFA Dispute Resolution Center, had jurisdiction over this matter in the initial stage. It is our contention that DRC, the FIFA DRC, did not possess the requisite jurisdiction to adjudicate over this. I will place reliance specifically on 2 standpoints. One is that when there is a specific exclusion of the FIFA DRC as to a jurisdiction, that's when there is a jurisdiction clause to exclude the jurisdiction of the FIFA DRC. It must be adhered to. And secondly, the failure of a party to countersign does not in any way invalidate the jurisdiction clause in a contract. To begin with, we acknowledge the provision of Article 23, sub 1 of the FIFA RSTP, which provides for the jurisdiction of the FIFA DRC. However, we are also placing reliance on Article 22, paragraph B of the FIFA RSTP, which states that parties may opt in writing to actually opt for another jurisdiction, which is the national MDRC of a particular country, which they might want to go for. And in fact, it is also further established that upon this establishment of standpoint or this jurisdiction, it must be shown that it is an exclusive jurisdiction placed upon the national resolution, this for NDRC in this case, Mr. Arbitrator. So our position is that although it is very certain and strong that the DRC is like the identified body by FIFA to sit upon every situation as a tribunal, employment dispute. However, when there is a specific writing in contract as to the exclusion of the FIFA DRC, it must be adhered to. We place reliance in the case of MKS, Cracovia, SSC versus Bojan, Puzi, Gaka, and FIFA. In this case, the panel was able to give precision and illumination to the concept of clarity and precision in the jurisdiction of the NDRC, stating that for the NDRC to overturn the decision of FIFA DRC, it must be shown that there was a specific analysis and specific identification in the contract of employment. Furthermore, we are also placing reliance on the case of AFC Astra versus Lionel da Silva, Ramahol, and FIFA. Now, in the combination of all of these principles and authorities, we hereby refer you to the fact of this case, Mr. Arbitrator. Precisely paragraph 5 in our statement of fact stipulates that Article 12 of the contract explicitly provides that in an event of dispute, only the National Dispute Resolution Chamber, which is the NDRC of the Nigerian Football Federation, will have the exclusive jurisdiction. Mr. Arbitrator, the use of the word only here is a very specific use of word as to stipulating that not DRC, not any other place, but just the NDRC will have the exclusive jurisdiction to adjudicate over matters of employment dispute. In light of this, this fulfills the provision of the law in Article 22, paragraph B of the FIFA RSTP, combined with the cast jurisprudence and every other principles outlined in this argument as to conferring jurisdiction on NDRC and not DRC. In line with this, we place submission on this standpoint one that DRC did not have the jurisdiction over this case, but NDRC has jurisdiction. On the second standpoint, we contend that the failure, although we identified that the Power Star FC did not countersign the agreement, so it is not a basis to actually say that FIFA DRC would still assume jurisdiction. Why? Because we are placing reliance on the case of C. Punik, Yerevan versus EAFC, Rapid, Bucharest, and FIFA, where it was held that continued performance by both parties, even when contract formalities are not in place. In this case, the counter signature will not stop the enforceability of this contract. In light of this, the sole question to be answered is, have both parties continued to engage in certain performances to indicate that they want to proceed with the contract? Yes, we conferred this honorable court to paragraph 7 of the fact of the case, which specifically stipulates that August 16, 2020, theory, Power Stars entered the transfer instruction into FIFA transfer matching system. That was the TMS. Furthermore, there were important proceedings from both parties to show that they wanted to proceed with this contract. This stipulates that the contract is binding. So if the contract is binding, then every clause in it is binding. And if every clause in it is binding, then the jurisdiction clause in it is binding. And the jurisdiction clause in it stipulates that not DRC, but NDRC must be conferred with the jurisdiction. In line with this, we submit. I'll pray you all the same. Moving to the second issue, which is whether or not there was a breach of contract. It is our firm contention that there was no breach of contract by Power Stars FC. I will place reliance on two standpoints. That one, that the purported contract between both parties were not expressed enough as to stipulating when bonuses will be paid. And secondly, we argue that the deduction of salaries is a reasonable internal disciplinary measures from the party, that's the team, Power Stars FC now, as to the failure of NED to actually fulfill certain obligations from his end. And we argue that these are not fundamental reasons enough as to constituting a breach of contract. To begin with, the provision of the law is clear on what a breach of contract would be. This is when a party or another party fails to actually perform a certain term of an element of a contract, which will in turn cause a gross breach, and in turn will actually cause the contract to be frustrated and not able to continue. Now, the question to be answered in this debate and in this submission is, the situation between Power Stars and NED, was it very strong enough to have constituted or frustrated the furtherance of this contract? Now, I place recourse to the fact of this case. Now, Article 4 stipulates that contracts, the payment of salaries must be stipulated according to a particular time, and which was followed. Now, furthermore, salary would commence upon the resumption of pre-season, which was also followed. Now, the only problem here is the issue of bonus. Now, the question is, after certain demands have been met as to the payment of bonus, why were the bonuses not paid? But the question is that, was there a stipulation in the contract that the bonuses will be paid at a specific time? The answer is no. So it is our reliance on the fact that there was no specificity as to when bonuses will be paid. Thus, there cannot be said that there was a breach of an agreement, because an agreement that was not constituted cannot be breached. This follows suit with the provision of Pacta Sunt Servanda, that is, an agreement must be followed. So if there was no agreement, then there is nothing to be followed. Now, I place reliance on the case of Club Atletico Penarol versus Carlos Abba, Benio Suarez, and Paris Saint-Germain. In this case, Mr. Arbitrator, it was held that minor delays or administrative issues do not constitute fundamental breach. Further, Mr. Arbitrator, I place reliance on Wigan Athletic FC versus Art of Midlothian, where the panel held that payment delays must be substantial and persistent to constitute breach of or warranting termination. In line with this, it is expressed that there was no entirety of a breach that was fundamental enough to actually cause a frustration in the contract. So there might be minor situations that could actually cause for internal measures to be taken. However, it's our contention that there was not enough breach to have warranted any of the parties to actually assert that there was a breach in contract. This will be our submission, and I'll seek the leave of this court to defer proceedings to my co-representative to handle 3, 4, and 5. Thank you very much, Mr. Arbitrator.
Mr. Arbitrator, may I proceed with my arguments?
Yes, please.
Please. The third merit is on the basis of whether or not there was just cause for NED Kikomeko to unilaterally terminate the contract. To this end, the appellant responds in the negative. Generally, the provision of the FIFA RSCP gives an enlightenment. It gives and allows for an individual to terminate the contract. However, it is contingent on an element. There must be a just cause. However, to determine whether or not there is a just cause, it is important for us to clarify the concept of just cause in order to determine whether NED Kikomeko fits within this context. And in light of this, the definition of just cause has been defined, has been given an illumination to pursuant to Article 14 of the FIFA RSCP 2025. It defines it as a circumstance in which a party can no longer reasonably be expected to continue a contractual obligation. And these have further received judicial blessings in the case of Palmeiras versus Dnipro. Now, just cause was defined here as a material breach such that weakens and severs the fundamentals of a contract. Now, in circumstances whereby a player have already perceived a just cause to terminate the contract, what is the procedure to follow? In circumstances like that, the procedure to follow is notify the defaulting party of their default in writing, as well as all the amounts that is owed and all other requisite items. Now, the failure to comply with this in line with Article 14b of the RSTP will result in a fatal effect on the claim of the just cause. And this has received judicial blessings in the case of Palmeiras versus FC Dnipro, as well as Franslino versus FC Donestis. That is even clarified that even in cases of delayed payment, it is still required that this procedural notice requirement be followed, as effect of not following it is fatal to a claim of just cause. Now, drawing from the aforesaid, in order to establish whether or not there was a just cause, there has to be a material breach such that renders the very foundations of the contract to be severed. Now, in light of this, the question that arises is whether or not there was indeed a material breach such that renders the foundations of the contract weakened or severed. The appellant responds in the negative. Now, as a serious breach occurred, no, pursuant to the provision of paragraph 14 to 15 of the fact of this case, which a claim is raised on the deduction of the salaries. This is an internal disciplinary measure. On the face of the Power Club FC, all that the Power Club FC sees is an individual that did not comply with the terms of the contract. Drawing from paragraph 14 to 15, he received a notice from the captain, and he acted on this notice to abstain from his contractual obligations. It is strict that the captain cannot act as an agent on behalf of the Power Club FC, or cannot act on their behalf. Now, it is our contention with respect to this that the act of him abstaining from his contractual obligation in light of his duties is an aberration, and the 500,000 naira deduction is a disciplinary measure to that effect, not a breach of contract. Secondly, on the basis of whether or not there was not paid the compensation, as earlier argued by my learned colleague here, the contract pursuant to paragraph 4 of the fact of this case has already outlined the stipulations in it, and it does not outline the specific period to pay such compensations. Thus, it's our contention that for all intents and purposes, it will have been paid during the subsistence of that contract. And the fact that it has not been paid yet does not mean that it will not be paid, because the contract in itself did not stipulate the exact point at which it is to be paid. It's our submission with respect to this that indeed there was no just cause to have warranted the termination of the contract unlawfully by NED. And we so submit in light of that with respect to this issue on the basis of the fourth merit, which is on the basis of whether the DRC's award was proportional. It's our submission that it was unfair and it was not proportional. Now, we'll be arguing this on 3 standpoints. Number 1, the absence of a serious breach. Second, the procedural breach of all the authoring pattern. And thirdly, the compensation violates proportionality. With respect to the first, we place reliance on our argument on just cause, that there was no material breach such that renders the entire contract to have been severed, such that weakens the foundations of it. We place reliance on that. And furthermore, we place reliance on the provision of the law pursuant to the case of Sevilla FC versus Udinese Calcio, where it was held that compensation is only payable where the other party is entirely at fault. And that is not the case here, because the fault and the issue here arises out of the inconsistencies of NED as he abstained from his duties and contractual obligations pursuant to the provision of paragraph 4 of the fact of this case. And secondly, on the basis of the audio authoring pattern, at the point where the mail was served to the CEO, he was ill, and at that point there was nothing he could have done. It would have been a different circumstance if there was, for instance, a club official email that would have been managed by a person. But in this sense, pursuant to paragraph 18 of the fact of this case, it was served to the CEO, his direct email, and at that point he was ill. It is our submission that the law does not command the impossible, and in light of that, the club has not been given reasonable a panel or a ground for fair hearing in this light. And with respect to the third standpoint, which is on the basis of proportionality, we so submit that the award that was awarded to NED was disproportional in line with his the loss that was suffered by him. Number one, we place reliance on the case of FC Nantes versus FIFA and All in the South Sports Club, where the CAS panel overturned a DRC default judgment for not being proportionate with the actual loss and not reflecting the true loss of the player. And that is the case here. It is also tried law that where the player does not intend or has not expressed his intention to be employed elsewhere, the payment to be made to him will be the residual level of the contract as he was pursuant to the provision of Article 17 sub 1 of the RSTB 2025. And in corroboration of that with the fact of the case, in fact, the entire sum that is to be paid to him does not exceed, is not up to 30 million naira. And in that sense, the DRC has already awarded 40 million naira. And this is grossly disproportionate to his actual losses and does not reflect the loss of Ned in this sense. And we saw submit in light of this that the award that was awarded to him was disproportionate, and in light of that, it is not tenable in law. On the basis of the fifth merit, it's our submission that in...
Sorry for a moment, we have reached the 15-minute mark. So would you like to take the additional 5 minutes to finish? Or would you like to finish in the rebuttal?
Yes, Mr. Arbitrator, we will take the 5 minutes to finish up our arguments and read the relief soft.
Perfect. All right, then let me just set the timer for 5 minutes, and you may go ahead.
It is our submission with respect to the fifth merit that the DRC's decision was unfair, as it has breached fundamental principles of law. For instance, the proportionality test, it is not proportional and it is grossly disproportionate to the actual loss of the player and does not reflect the actual loss of the player. And in that sense, we so submit with respect to this issue that the action and the decision of the DRC in light of the entire circumstances is grossly unfair and disproportionate and does not reflect the true loss of the player. And we pray this honorable court would say, I seek the leave of this court to defer proceedings to my learned colleague to read out the relief sought.
If it pleases you, Mr. Arbitrator, I would like to proceed with my prayers. In light of the argument canvassed and positions of the law adduced, it is our contention that I would pray that this honorable court of arbitration, or that the FIFA DRC did not have the jurisdiction to have adjudicated over this matter in the first place. Secondly, we also pray that this honorable court of arbitration hold that there was no material breach of contract from Power Stars FC. Furthermore, Mr. Arbitrator, we also pray that it is established and asserted in this case that Ned had no just cause for the unilateral termination of the contract. Fourth, Mr. Arbitrator, we also pray that this court hold that this panel should also, in fact, reverse the compensation award, which was awarded by DRC to Ned, in light of the fact that it was not proportional, it does not reflect the actual loss, and certain legal perspectives and authorities will not adhere to in the establishment of this. Finally, we also pray that the respondent is to bear the cost of arbitration and every proceeding and additional legal fee incurred by Ned. Further, this is our submission and prayer, and we pray that this honorable court of arbitration will do the same. Thank you, Mr. Arbitrator.
Thank you. Now, just as a matter of fact, you took only 2 minutes additional. Nonetheless, of course, if the respondent requires 5 minutes to end, it will be granted. However, it means that we should have a bit of additional time in the rebuttal. From my side, I will reserve questions until the end, until the rebuttals have both been finished, and potentially ask some questions. Or during the rebuttals, I will decide that later. But for now, I'd like to pass the floor to the respondent. Respondent, are you ready to start?
Just a deep breath.
Yeah, exactly. Take a deep breath, just relax, it'll be all okay. So I will start your timer, and please go ahead.
Yes, thank you, Mr. Arbitrator. Again, Daniel Walusimbi, my name, appearing for the respondent in this matter with my co-counsel, Kubiriza Morgan. Yes, Mr. Arbitrator, we have listened attentively and carefully to the submissions of the appellant, and in response to their submissions, I will, as the lead counsel, I will handle the issue of admissibility, and the issue of whether the FIFA DRC had the jurisdiction to adjudicate and decide on the employment-related dispute. And then my co-counsel will handle the issue of whether the respondent terminated the contract with the just cause. And we'll also go ahead and read our prayers, and that's how we will proceed. If it may please this honorable panel, I would like to proceed to submit on the issue of admissibility. Mr. Arbitrator, the respondent does not dispute the jurisdiction. The respondent does not dispute the jurisdiction of this honorable court. However, the respondent disputes the admissibility of the matter before this honorable panel because of the failure of the appellant to request the grounds for the appeal decision within the 10 days after the decision had been notified to them, as required by Article 15, Paragraph 5 of the FIFA Procedure Rules governing the Football Tribunal of 2023, as will be referred to hereinafter as the FIFA DRC rules. Mr. Arbitrator, Article 15 of the FIFA DRC rules complements Article 57 of the FIFA statutes that talks about the admissibility of CAS. And its fulfillment must be verified and as a matter of admissibility of appeal to CAS. And this was held in the CAS case of 2023, appeal number 9424 of Halwada Sporting Club versus FIFA and Sinister at paragraph 46, page 13. Mr. Arbitrator, the said article 15, paragraph 5, if I may read it verbatim, it says that where no procedural costs are ordered, a party has 10 calendar days from the notification of the operative part of the decision to request the grounds of the decision. Failure to comply with the time limit shall result in the decision becoming final and binding, and the party will be deemed to have waived this right to file an appeal. And the time limit, to lodge an appeal begins upon notification of the grounds of the decision. Mr. Arbitrator, this same article was reiterated in the case, in the CAS case of 2019, 2019 Appeal 6252 of Wada Athletic Club versus FIFA and two others at paragraph 91, where the appeal was deemed inadmissible due to the appellant's failure to request the grounds of the appeal decision within the time limit foreseen in Article 15, paragraph 5 of DRC rules. Mr. Arbitrator, in this present situation, as clearly evidenced by paragraph 17, line 3 of the facts, the decision was made, notified to the appellant on the 20th of March 2025. And the appellant asked for the grounds of the decision on the 31st of March 2025, 11 days after the decision was made, a day extra of the prescribed 10 days. And this means that the decision had already become final and binding, and it was unappealable. And therefore, it is from this premise that the respondent firmly submits that the matter before this honorable panel is inadmissible, as it fails to meet the requirements of Article 15, paragraph 5 of the FIFA DRC rules, and should be dismissed without going into the merits to save court's time and resources. Mr. Arbitrator, in the event that this panel finds it in its wisdom that the matter is admissible, allow me to proceed and make my submission on the issue of whether the FIFA DRC had the jurisdiction to adjudicate on the employment-related dispute. Mr. Arbitrator, Article 22, paragraph 1B of the FIFA RSTP addresses the jurisdiction of the FIFA DRC. And it provides that FIFA is competent to hear an employment-related dispute between a club and a player of an international dimension. and the parties can explicitly opt in writing for such disputes to be decided by National Dispute Resolution Chamber. Any such jurisdiction clause must be exclusive and included either directly in the contract or in the collective bargaining agreement applicable to the parties. Mr. Arbitrator, for the element of international dimension, as a general rule stated in the CAS decision of 2016, appeal number 4441 of Jon van Beekling versus Perita and FIFA at paragraph 29, it was held that a matter is of an international dimension if the player concerned is not a national of the country of the association with which the relevant club is affiliated. And Mr. Arbitrator, going to the facts, in this present situation, the dispute is of an international dimension because the respondent is a Ugandan national, as clearly evidenced in paragraph 1 of the facts, plying his football trade in Nigeria. Mr. Arbitrator, looking at the element of exclusive jurisdiction clause, Mr. Arbitrator, the respondent understands that having an exclusive jurisdiction clause means that the dispute can't be later taken to FIFA or CAS unless the National Dispute Resolution Chamber is found not to meet the FIFA standards as laid down in the FIFA Circular number 1010. And just to mention a few of the standards, the principle of fair hearing must be there, and as in the Dispute Resolution Chamber must be independent and impartial, and it must treat all the parties equally. Looking at the facts, it is difficult to determine whether the Nigerian National Dispute Resolution Chamber met the FIFA standards. But nonetheless, as clearly held in the CAS decision of 2024, appeal number of CAS decision 2024, appeal number 10,400 of Alice Limassol Football Club versus Abdul Jalil, at page 25, paragraph 68, an exclusive jurisdiction clause should be agreed upon as in voluntarily. And in case of a standard employment contract, there is no employment agreement. So, Mr. Arbitrator, this means that the condition of the contract should be decided through negotiation or mutual understanding. So, Mr. Arbitrator, in the present situation, the contract that the appellant gave to the respondent under paragraph 4 of the facts was a standard contract, and there was no voluntary agreement on the article, on Article 12 of the contract that deviated from the default jurisdiction of the FIFA DRC, as provided under Article 22, paragraph 1 of the FIFA RSTP. Therefore, from that premise, the FIFA DRC had jurisdiction to adjudicate and decide on the employment-related dispute between the parties because the exclusive jurisdiction clause that the appellant alleged under Article 12 of the contract could not be considered as a valid exclusive jurisdiction clause because it was not agreed upon voluntarily, as held in the CAS case. So in the CAS decision, 2024, appeal number 10,400 of Aris Limassol Football Club of Greece versus Abdul Jalil at paragraph 70 on page 25. Mr. Arbitrator, having established that FIFA DRC had full jurisdiction, I will now yield the floor to my co-counsel to make the submission on issue 3 of whether the respondent had terminated the contract with the just cause, and go in also to render our prayers. Thank you.
Mr. Arbitrator, once again, my name is Kubiriza Morgan, and I'm going to make submission on whether the employment contract was terminated with or without just cause, whether there was a breach of this contract, and I will go further to discuss the just cause in detail. Mr. Arbitrator, all this is driven on the principle of pacta sunt servanda, which proves that contracts must be performed in good faith until the parties conscientiously adopt a new contractual agreement, as held in a case, appeal number 3091 FC Nanti versus FIFA. Mr. Arbitrator, though Article 13 of the RSTP provides that a contract between a professional and a club may only be terminated upon expiry of the term of the contract or by mutual agreement, Article 14 of the FIFA RSTP stipulates to the contrary, that a contract may be terminated by either party without consequences of any kind, either payment of compensation or imposition of sporting sanctions, where there is a just cause. Mr. Arbitrator, just cause has been defined in the case 2020 appeal number 6992, case of Dalian Professional Football Club versus David Cortez and FIFA, as any circumstances which render the continuation of employment relationship in good faith unreasonable for the party giving in notice. Mr. Arbitrator, for just cause to be proven that it exists, two requirements or two limbs must be made. That is the substantive requirement, which deals with the contents of the contract and the performance, and then the second limb, which is the procedural requirement, which speaks to the sufficient notice of defaulting the party. All of which, the two limbs, they were well discussed in the case case of 2023 appeal number 94444 U Krayova 1948 SA versus Marko Jovic. Mr. Arbitrator, moving on to the first limb, that is substantive aspect. Or the first one, which is the substantive aspect. This one, it consists of the pattern of behavior that render a continuation of unemployment in good faith unreasonable and impossible for the party giving notice. Mr. Arbitrator, under this substantive limb, there must be a material breach, and of which the material breach occurs in particular when the main terms and conditions, this is the major point, that when the main terms and conditions under which the contract was entered into are no longer implemented, this circumstance must be such that, according to the rule of good faith, the party terminating the employment relationship cannot be required to continue. As laid down in paragraph 11 of the moot facts, Article 4 of the contract contained an undertaking from the appellant to pay a respondent a monthly salary of 1 million naira, with a bonus of 100,000 for each home win and 150 for the away win. However, the respondent participated in 30 league games, recording 10 away wins and recording 14 home wins. When you mount this, the bonuses he had to get, it mounted to 3,100,000 naira. This is equivalent to 3 months' salary, and these bonuses were not paid. Mr. Arbitrator, these are the fundamentals which were in Article 4 of this very contract. Mr. Arbitrator, Article 14 of the FIFA RSTP stipulates that in case of any club unlawfully failing to pay a player at least 2 monthly salaries on their due dates, the player will be deemed to have a just cause to terminate his contract, provided that he has put the debtor club in default in writing and granted a deadline of at least 15 days for the debtor club to fully comply with the financial obligations. Mr. Arbitrator, paragraph 15 from the facts stipulates that on the 30th of September 2024, Ned, through his Anthony, wrote a letter to demand his unpaid bonuses and salary deduction. Mr. Arbitrator, they sent this through his through the WhatsApp of the CEO of Power FC, but the club did not respond to the communication.
Let me just stop you right there.
And then when they went,
Sorry, guys, the time is up, so I will just continue with the additional 5 minutes if you're okay with that. So your 15-minute time is up. Would you like to continue with the additional
Yes,
5 minutes?
want to
Yeah?
con-
Perfect. Proceed, please.
Yes. Mr. Arbitrator. Thank you, Mr. Arbitrator. When you look on from 30th September to the 20th of October, on when when the contract was terminated, there was an extra of 5 days, meaning that the refusal of to pay part or all the salary of the employee has been considered a just cause for terminating the contract unilaterally. And also, this falls under the class of breach of the fundamental terms of the contract. It is the submission that more than 2 months' salary of the month of August. This is evident from paragraph 14 of the moot fact that when they wrote to the CEO, they were demanding him 3 months' salary, which was not paid. That is already a breach of the contract. Now, moving on to the second one, the second limb, that is the procedural aspect. The procedural aspect of showing just cause requires giving sufficient notice to the party, not meeting its obligation under the contract to enable them perform. Mr. Arbitrator, the arbitration award, class 2016 appeal number 1180, Galatasaray SK versus Franklin Ballet and Olympique de Marseille, gives illustration to this as follows. A prerequisite for terminating because of late payment is that the appellant should have given a warning. This follows from the principle of good faith for the breach of its duty, objectively, from the outset, so grave that it would have been unreasonable to expect an appellant to continue employment. However, if that is the case, the appellant must, before terminating the contract, let the respondent know firstly that he is complaining and the respondent conduct is not in accordance with the contract. As a general rule, the principle of good faith, giving a warning is just a prerequisite for terminating a contract because of late payment. Paragraph 15 of the facts proves that the respondent gave notice that was not attended to, Mr. Arbitrator. It is our submission that the respondent, Ned Chikomeko, was undone by the action of the club. The fact that the appellant would go 24 matches of the season without paying the match bonuses and failure to the respondent to demand the letter deeming the communication unofficial, when all the initial negotiations of the contract were done through the WhatsApp, was proof enough that the appellant didn't have intentions to meet the obligation. Mr. Arbitrator, with the submission laid out, it is our prayer that, 1, the 20th March 2025 decision of the FIFA Dispute Resolution Chamber be upheld. 2, the respondents are awarded the cost of legal assistance and the representation and the other costs related to this present arbitration proceedings. I submit.
Perfect. Thank you for that. You're within the additional 5 minutes, so I appreciate that. Now, what I'd like to do is, obviously, you're going to have an opportunity for a rebuttal. Now, you will have 5 minutes each side, and once we finish, I might have 1 or 2 questions to pose to both sides, obviously taking turns and answering them. I won't require 2 significant detailed responses. So that being said, then I pass the floor to the appellant for your rebuttal, and I will start the clock for 5 minutes. So please go ahead.
Thank you very much, Mr. Arbitrator. May I confirm if I'm being heard clearly, please?
Sorry, can you repeat that?
I said, may I confirm if I'm being heard clearly, please?
Yes. It's all good.
Yes.
Thank you very much, Mr. Arbitrator. So basically, our rebuttal will be premised on 3 solid grounds, and I'll be taking 2 grounds which borders on the admissibility and the jurisdiction, while I'll defer proceedings to my co-representative to take the rebuttals on the third ground, which is the just cause. Now, the first ground raised by the respondent in this case, they said that this appeal will not be admissible in this court because we have failed to comply with Article 15 of the FIFA DRC rules. Now, our response is that basically, from the fact of the case, it is express and unambiguous. I commend the court to paragraph 19 precisely, paragraph 18, where it stipulates that on the FIFA legal portal, Ned Anthony's used Power Stars FC email address as a respondent contact. The CEO, however, was hospitalized and could not access his mail. Consequently, the FIFA DRC passed a default decision on 20th of March 2025, awarding Ned 40 million naira. Now, to paragraph 19, stipulates that Power Stars FC requested for the grounds of the FIFA DRC decision on 31st March 2025. Calculating the date of 21st to 31st, this stipulates that there is a compliance with the date. Now, the question of whether or not they got the appeal within a stipulated date is not the fault of the appellant in this case, because they actually got the response on the 30th of April 2025. But in the entirety of the situation of this case, it is our contention that there are circumstances to assert that the entire process of the institution of action was already faulted, including from the unilateral termination, even to the jurisdiction of DRC, and even to the fact that the CEO was hospitalized and was sick for a certain moment. However, there were certain efforts, reasonable efforts, substantial effort that was made to actually comply with the procedures of Article 15 of the FIFA DRC procedures. In light of this, we pray that it would amount to unfairness for this court not to be able to admit this matter. And we pray in the court in its magnanimity and confidence admits this matter and sit over it. Flowing to the second head of argument, which is on the DRC's jurisdiction, the provision of Article 22, paragraph B of the FIFA RSTP is express, clear, settled, and unambiguous. It provides that there are certain elements that must be fulfilled. If these elements are fulfilled, then the exclusive jurisdiction of DRC will be altered and excluded. This is provided when party opt in an explicit writing to actually demand for the jurisdiction of an NDRC of the country. Now, apart from that, the argument from the respondent stipulated that there are other parameters to meet, and we admit that, especially in the case of Grupo Desportivo de Chaves versus Kevin Lenin and FIFA, where the court outlines 4 elements, which involves the independence of NDRC, the fact that the NDRC in question must be fair, and the fact that the player must be of international dimension. Now, it is clear that the player is of international dimension, and now the question of the independence and the fairness of NDRC, we assert that it is a question of fact and not a question of law. Now, although it is contingent on the appellant to prove that they are independent, however, it is not stipulated in the fact of this case that there are reasons to believe that NDRC is not independent or will not be fair. In light of this, the real question to answer before this Honorable Court of Arbitration is whether or not there has been an express stipulation as to the conferring of jurisdiction on the FIFA, on the NDRC NFFA, which in this case was stipulated in paragraph 5 of the moot fact, which was reflected in Article 12, which confers jurisdiction exclusively with the use of the word only. Mr. Arbitrator, the use of the word only means that the exclusiveness of this contract, of this employment dispute, will only be ascertained and settled by the NDRC and not the FIFA DRC. In light of this, we hereby submit again that DRC did not possess the requisite jurisdiction over this matter, but NDRC did those. Now, I'll defer proceedings to my co-representative to canvass the rebuttal on the last part, which is just cause. Thank you very much, Mr. Arbitrator.
All right, guys, let me just stop you. You have 30 seconds left. How long do you think you need?
All right. If you can avail us with 1 minute. Thank you very much. 1 minute.
All right. I will grant you 2 minutes, and then the same will be granted to the respondent. So please go ahead.
Thank you very much.
Mr. Arbitrator, on the basis of whether or not there was just cause, we retain our contention that indeed there was no just cause to have unilaterally warranted NET to have terminated the contract. On the basis of whether it applies, we refer this Honorable Court to the specific reading of Article 14b of the RSTB 2025. It is to the effect that the party in contention should notify the defaulting party in writing. The act of notifying the other party on WhatsApp does not reflect the true intention of the purpose of this act. If there are procedural requirements to be met, it is only fitting that such requirements be met and be followed to the letter of the law. The alternative measure as stipulated pursuant to the same provision is asked to be incorporated within the context of the contract. And the question that arises is whether or not the alternative methods of notice have been incorporated within the context of the contract. We respond in the negative. The provision of paragraph 4 of the fact of this case that outlines the stipulations of the contract are very clear and unambiguous. And when matters sensitive as these are to be notified to the Power Club FC, it is required that the provision of the law with respect to notifying the defaulting party of the amount they owe, of their default, as well as it must be in writing, and this has not been complied with pursuant to the fact of this case. And secondly, on the basis of whether or not the 500,000 naira will still amount to a material breach under the context of the contract, we retain our position that it does not amount to a material breach, as all that has occurred is an internal disciplinary measure that is in response to the act of NED being inconsistent with respect to its contractual obligations. And in this light, it is our submission with respect to this that indeed there has been no just cause to have warranted the unilateral termination of the contract by NED, and in that light, it is unlawful and illegal. This is the contention of the appellant, and we pray this honorable court holds the same. Thank you, Mr. Arbitrator.
Thank you as well. You were within the additional 2 minutes. Now, for the respondent, you will get 7 minutes from the outset, given that they were afforded the same. So you may use this time to your best to then proceed with your rebuttal.
Yes. Thank you, Mr. Arbitrator. Responding to the first apparent about the issue of admissibility, he argued that actually the CEO of the appellant was hospitalized and it was a default judgment. But I would want to, refer the Mr. Arbitrator to Article 15, Paragraph 2 of the FIFA Procedure Rules governing the Football Tribunal, where it states that notification is deemed complete when the decision is communicated to the party. And it goes further to say that notification of unauthorized representative will be regarded as notification of the party which they represent. So in this case, the appellant, as an email was sent to the CEO. And also in the CAS case in the CAS decision of 2019, appeal number 6253 of Wydad Athletic Football Club versus FIFA and 2 others, at paragraph 85, it was held that an electronic notification by email is considered as a valid means of communication, and it will be deemed sufficient to establish time limits and their observance. So indeed, the appellant was notified through the email of the CEO, which was on the FIFA legal. The appellant has also argued that the CEO was hospitalized, but this does not take away the fact that the appellant was notified of the decision. And in the CAS case of 2019, appeal number 6253 of Wydad Athletic Club of Morocco versus FIFA and others, on paragraph 81, it was stated that a decision is considered notified at the moment it reaches the respondent's sphere of control. And what matters is whether the person can become aware of the content of the decision, not whether the person has done so. So in this dispute, the appellant arguing that the CEO was hospitalized, it is immaterial. And on the second issue of whether the FIFA DRC had jurisdiction, the appellant did not address my issue of the issue of not agreeing upon the exclusive jurisdiction clause voluntarily. And it's the main issue why FIFA DRC had the jurisdiction to hear the matter, because in case of a standard contract, employment contract, like the one the appellant gave to the respondent, it does not have a voluntary agreement on it. And failure to have a voluntary agreement on the exclusive jurisdiction clause, that clause becomes invalid. And this was reiterated in the case of Limassol of Aris Limassol FC of Greece versus Abdul at paragraph 68 on page 25. So it is our submission that indeed the FIFA DRC had the jurisdiction to adjudicate on the matter and decide it. Thank you.
Thank you. Mr. Arbitrator, the appellant, they have submitted that there was no material breach. Mr. Arbitrator, it is our submission that for the material breach to occur, remember the material breach, it is under what we call the substantive aspect or the first limb. And this limb is all about whether there was a behavior which would lead one of the parties to stop or to discontinue the contract. And in this fact, we think that Article 4, when you go in the facts, paragraph number 11, Article 4 of the contract stipulates that there were actually the very first one, because you have Article 4, it talks about the salary, which is 1 million, and talks about the bonuses. They submitted that the bonuses had no when to be paid. They had no time limit to be paid. But why is it that they are paying in the salary? When you look at this very article number 4, it stipulates that 1 million had to be paid, and then bonuses had to be paid, of which that was the ground for this contract. Those were the terms, those were the fundamentals of the contract, which were breached. So, Mr. Arbitrator, it is our submission that there was breach of the, there was material breach under the substantive aspect. And furthermore, they went on to Article 14, Article 14, bis of the FIFA RSTP. And then they say that there was no writing. But remember, when you look at this contract, the way it began by use of WhatsApp. That's how the contract began. So meaning that since it began by use of WhatsApp messages, even the contract was signed, they sent it via WhatsApp. It means that indeed, when they sent him on the 30th, when they sent him the notice, it was a valid one. Because when you read on paragraph 15, that through the Attorney General, they sent him a notice demanding the salary. So meaning that since they sent him the notice and they used the same measure which was initially used, it is clear evidence that the communication used was valid, and indeed this man breached the contract which they had with him, and the termination of the contract was with a just cause. I submit. Thank you.
Perfect. We have 12 seconds to spare. Now, that having been said, I promised that there would be questions. Now, albeit I will not go into too much detail on any question. I believe I have perhaps 2 or 3 questions. I will keep them short, and I will ask that the answers are also maximum 1 minute, 30 seconds. So the first question, because this has been largely discussed and disputed by the two sides, is regarding the communication and the default notice sent via WhatsApp. So my question with this, and it's the same to both sides, and I'll give the appellant the first chance and then the respondent, is in certain cases where there's something at stake, such as a contract's validity, a contract's extension, termination, etc., is there or should there be, or is there a prescribed form, a certain level of formality to such communications, and whether or not in this case that was required? So whether there was a certain formality required to send the default notice, and also whether there was anything outlined in the contract between the parties. So first I'll give the appellant an opportunity and then the respondent. I'll time it, but if you can keep the answer short to about 1 minute. Yeah, so please go ahead. And if you need clarification, let me know.
Thank you, Mr. Arbitrator, for your question. And in response to your question, it is fundamental that when the law already prescribes a method of doing something, it is only fitting that such method of doing it should be complied with. And in light of this, the provision of Article 14b is very clear. It already gives a prescription as to how notices are to be sent. And in that light, notices are to be sent in writing. So it is immaterial if the contract may have commenced on WhatsApp or whatsoever. What is important is whether or not the law prescribes a method for such things to be done. And in respect of that, in the context of this case, the law does provide for something like that. And it's our contention that since the formal procedure as defined under law has not been met with, then such procedure is deemed unofficial.
Let me just follow up on that. Because you mentioned that it should be in writing. That's clear that it should be in writing, but wouldn't you say that a WhatsApp message is done in writing as well? So what is the level of formality that's expected in the writing?
Mr. Arbitrator, if I may speak on this, I would like to ask, should I respond as in my position as the appellant or from a general perspective in my understanding of football law? Please.
I mean, in this case, you are acting for the appellant, so you keep yourself within the framework of the appellant, but obviously I believe that it generally also applies how the law works in this particular case.
All right, thank you very much, Mr. Arbitrator. Our contention is that the entirety of this contract did not transpire as a WhatsApp chat. So the point is that there are inconsistencies at some point. So it would amount to a level of lack of consistency to actually change the trend of things, because initially there was serious communications that were communicated in certain writings, which was not in the WhatsApp communication. So the use of WhatsApp communication was not the entirety of the course of events. So that's why we are certain that when there is already a provision of the law that is stipulating a concept as to writing, then let the writing continue, especially in the fact that there has been a course of things before things got changed. So that's why we are contending that the communication through WhatsApp may not entirely fulfill the provision of the law stipulated. That's our contention, Mr. Arbitrator.
Thank you. Now for the respondent, same question. Let me know if you need any clarification as well.
Thank you, Mr. Arbitrator.
Can I be heard, please?
Sorry?
Mr. Arbitrator?
Yeah, do you guys
Can I
hear
ask
me?
for some clarity again?
Yes.
I just want to have some more clarity about your question.
Yes. Okay.
You're talking about the formalities of communicating through WhatsApp?
Yes, you have mentioned that WhatsApp was the way the contract was concluded, and you have mentioned that that is also why it was the chosen method. But the question is whether this communication meets the required formalities when we're talking about something as significant as a contract termination.
Thank you, Mr. Arbitrator. First, referring to the CAS decision of 2024, appeal number 10,646 of Club A versus B at paragraph 67 on page 13, it was held that communication via WhatsApp is a permissible mode of communication. Then also taking you to the CAS case of 2019, appeal number 6253 of Wydad Athletic Club versus FIFA and 2 others at paragraph 81, it was stated that a decision to be considered notified the moment it reaches the recipient's sphere of control, it will be deemed as communication. So in this instance, when it comes to the formalities of WhatsApp, Mr. Arbitrator, it is our submission that as long as we can prove that the communication, this is a permissible mode of communication, that it was actually, it reached the sphere of control of the other party, I would think it will meet the formalities of communication. I submit.
Can you please repeat the first case that you mentioned to me? Something with 10,600 or 10,060, something like that?
Yes, yes. Casquez decision. Can you hear me?
Yes, yes.
Can you hear me?
Yes,
Casquez
Yes, we can.
decision of 2024.
Yes.
Let me repeat, CAS decision of 2024, appeal number 10646, Club A versus B, at paragraph 67 on page 13. It was held that the communication via WhatsApp is a permissible mode of communication.
Okay. Thank you. Now, moving forward, I will not take much more time. I did have, well, essentially just one final question. I will limit myself to that. And we're talking here about Article 14. We're talking about the requirements of Article 14. We're talking about the breach of contract. So my question to both sides is, what is Article 14 composed of, and what has Article 14 required, and now whether truly you believe whether those were met, and if not, or if did not need to be, then whether there's an exception to this.
Please, Mr. Arbitrator, I would like to ask if you could rephrase the question, please, for clarity.
Sure. So I will not give you too much hint, but generally what we've spoken about, and both of you have referenced, if you referenced Article 14 bis. So Article 14 bis sets out a certain requirements, certain criteria to follow, a procedure to follow, as well as a certain substance to it. So the question is whether in this case either side believes that these, as prescribed by Article 14, have been met, and if one believes that if it was not met, then why not? Or alternatively, whether there are exceptions to Article 14 bis if the conditions were not met or were not required to be met at the relevant time, with attention to circumstances.
All right. Thank you very much, Mr. Arbitrator. This goes to the root of whether or not there was a breach of contract, and whether or not by the action of a party there has been frustration in the contract. Now, the provision of Article 14b is talking about that in the case of the club unlawfully failing to pay a player at least 2 monthly salaries, there is a specificity in the provision of this 2 monthly salaries, at least 2 monthly salaries. On their due dates, the player will be deemed to have a just cause to terminate. Now, the question here is not the question here to ascertain the real ground for a just cause is, has there been a delay in the payment of at least 2 months' salaries? The answer is no. Now, the very important thing to note is that initially, the first question as to whether or not there should be a just cause for terminating contract was as a result of bonuses that were not paid, and we argued that there were not stipulated time as to the payment of bonuses. And we also rely on several authorities' cast jurisprudence as to the fact that delay in payment of dues cannot be fundamental enough to warrant a breach, not to talk of a just cause for the unilateral termination of a contract. Now, flowing ahead to the issue of the salaries, the delay in salaries. Now, we argue that this was as a result of the internal measures that were taken by the club, and this does not reflect an intention by the party to actually terminate the contract, because there were still developments from both parties. That's from Power Stars FC. Now, to be very specific, minor delays is an exception. If there was a minor delay and it was not a very fundamental delay as to show that the club actually intends to frustrate the contract, then it would amount to a reason to stop the act of just cause to terminate the contract. Furthermore, when there is a breach caused by terminating party, that's the point is that is if one of the parties, that is the party that unilaterally terminated the contract, is contributory to the entirety of the event that caused the situation or that frustrated the contract, then it would be unfair to assert that just cause will still avail the person. Now, in this case, there was a situation where there was a miscommunication between the captain and Ned in this case. Now, as a result of this, it must be asserted that the captain did not act for the club. Now, this situation had already contributed to the frustration of the club. Now, it is on this ground that the club had failed to stipulate certain provisions of the contract. That is the payment in due time. Now, it is our argument that this little contribution has contributed to what actually led to the just cause that Ned claimed he had. So it is expressed that when there is a contributory negligence or when there is a contributory act from one of the parties, then the act of just cause will not be satisfied. Thank you very much, Mr. Arbitrator.
Now for the respondent, same question.
Mr. Arbitrator, Article 14 of the FIFA area STP, the first question you asked, it was, what is it composed of? First of all, it is composed of the unlawful failure of a player not to be paid 2 monthly salaries on their due dates. That's the first one.
Yes.
And then when you go into our facts paragraph 15, line 2, it states that he was claiming outstanding wages exceeding 3 months, meaning that this was a just cause. Then secondly, it provides for a notice that the person should be a default in writing and has to be granted a deadline of 15 days for the data club. So the notice must be of 15 days. Again, if you go still in our very facts, paragraph 15 and paragraph 16, they provide for the same. Paragraph 15, it provides that on the 30th of September 2024, that's when the letter was sent. And then paragraph 16, subsequently on the 20th of October, that's when the contract was terminated, meaning there was an allowance of 20 days. And the law provides for 15 days, meaning there was an extra 5 days which were given to the club before it was terminated. And then the expectation is, yes, indeed, there was a breach of contract because its fundamentals and terms and conditions were breached. And also, lastly, when you look at the bonus, the total bonus was 3,100,000 naira, which is an equivalent of 3 months' salary. So, indeed, this is really proof that the fundamentals were indeed the just cause was there, so that this contract had to be terminated. I submit.
Okay, well, I have no further questions to either side or in general. So, prior to closing and before my feedback and comments that I may provide, the way the case is usually closed is first, I will have to ask you whether there are any objections to the way the hearing was conducted and whether your right to be heard was met. So first, for the appellant.
Thank you very much, Mr. Abitrito. I must commend your the way you handled the whole thing, your magnanimity, because at some point we could not join on time, and we appreciate your discretion to halt the development of things. And thank you. In all, it was a really nice experience. Thank you very much.
And on your right to be heard, was it complied with?
Yes, Mr. Arbitrator. In fact, it was really complied with. We appreciate the fact that you were very fair as to granting us additional time at some point, and we cannot be more grateful. Thank you very much.
Now for the respondent. Was your right to be heard complied with? And do you have any objections to the procedure?
Yes, and we have no objection to the procedure. And indeed, our right to be heard was met, given that you gave us extra minutes to express ourselves. We appreciate. Thank you.
Perfect. All right, now, gents, your results and stuff will be communicated to the Football Law Annual Moot. However, I have been given the opportunity, should I wish to give you a bit of feedback. I will not point out anything individual, but rather give you some general remarks. First things first, obviously, I understand that it can be a little bit stressful. You prepare a lot, you come out here, but at the end of the day, your presentation and will depend on several elements. There's the element of whether there's connection, whether that's on my side, whether that's on your side, whether that's on the other party's side. So I believe all of you have done the best you could, and also remain calm, composed. So that's one important aspect. The second aspect is also, of course, is how you present yourself. I believe all of you have done a fantastic job in presenting yourselves, in particularly not just professionally, but also dressed up well. So good job on that. But also the way you speak and the way you stress. So always make sure that you don't let the stress and the nerves or the excitement get the best of you. It has happened to me. It will continue to happen to all of you. The reason for that is simply because you just need the experience and the comfort. Once you realize that this court is your comfort zone, then all of that stress will really disappear. However, that being said, I think all of you did a good job going through your points, stressing where it needed to be stressed. And I liked that both sides listened to each other, because when you go to a case like this, as the appellant, you're generally on the back foot, because what you're doing is you're presenting your case based on what you received, the decision, as well as the respondents, or whatever position that they were in or whatever they submitted last. And then for the respondent, obviously, your task is to listen and to respond. So I think that you guys were good in those roles. Now, when it comes to the questions, we have discussed 14 bis in detail, and you have discussed it in your submission. You have discussed it also today. But when a question like that comes from the arbitrator, like me, you may feel like, well, I have already said this. What is he looking for? What you do is what you did now. You ask for clarification. You provide what you believe is the most suitable answer. You try to answer it as much as you can to the best of your ability. And should you require, you can always ask for a moment to confer with your co-counsel, or just a moment, just simply say, may I have a moment to answer? You don't need to give a reason. That's also good. And especially given that you're the appellant, again, if I provide a general question as such, the respondent will have your time to prepare. So you can always ask to give a bit of time. And then, finally, talking about the form of communication, this was something that I felt needed to be asked. It is something that when a question like this is asked, you might think of it as a hint from the arbitrator, as it's something that they might be looking for, something they'd like to hear. But all of that being said, again, just congratulations for having done this. You will do many more of them, and you will improve as you go along. But both teams, I believe, did well. And in particular, one thing that you will account for is hearings, even if there's a hearing schedule, which we didn't have, but we had, a preliminary understanding of the times. Hearings can, if it goes well, if it's a good day, you might be done, faster. But experience tells that it usually will have complications. It will take longer. I can tell you that the longest online hearing at CAS that we've had is almost exactly 13 hours. So it can be long. It can be, frustrating and tiring. This was, of course, longer. If we look at it on paper, it would have been 40 minutes. Now we're already at an hour and a half. But that's just how the things go. So I will not take any more time. Just once more congratulating you on today. Both of you should feel like you've done a fantastic job. And I hope that I will see all of you either in the next edition or by my side or as an opponent before any of the tribunals. And keep in mind that if that does happen, in the court we'll be competitors, but outside we'll share a coffee or a drink. So with that, I will close today and I will pass back the floor to the Football Law Annual Moot if someone is here. Yes, there we go. So I'm passing the floor back.
Yes. Thank you very much, Mr. Maton. Thank you very much to our counsel, the appellants and respondents. Thankfully, we haven't done 13 hours rather, but it's been a worthwhile session. On my end, it's been exciting to listen to the arguments, and indeed, this one could actually be a tough one for you, Mr. Kish there. But wonderful presentation by our contestants there. There's a lot to learn. There's a lot to pick. The flipping on the pages on Article 14 bis, 12 bis, they're in, and Article 22. It just gets better. Wonderful presentations, and from all of us here at the Football Law Annual Moot, we are very grateful for this experience. Pick every lesson that you can from this kind of exercise. It can only make us better going forward. And with the competitions going forward, again, it gets tighter from one arbitrator, possibly three. And that makes it even more exciting with the barrage of questions coming through. This session, indeed, has been brought to an end by the arbitrator. I don't want to push it much longer. And I would love to wish you all a wonderful evening. Thank you very much. Be well and stay well.
Thank you. Take care.